Mentioning.
My lords, kindly, Lord, may I please seek leave to file an appeal?
When was the order passed?
The 22nd January 2024, but it was passed in our absence. We have only now, my lord, come to learn about the order.
You are not parties.
My lord, we were in the nature of pro forma defendant. We were not participating in the suit. It was an innocuous suit, really, until this order was passed, my lord, which has created havoc for us.
When did you apply for certified copy?
My lord, we haven't made an application yet, but there's a pleading that we are in process of applying. It will be done today itself.
No, sir.
We will.
No. Apply, at least apply. At least apply and come back, sir.
Wait.
24 January order. Firstly, whether we believe your client or not that they didn't know is one thing. Even if we assume, even then, still you haven't applied.
My lord, we will. I'm grateful.
Yes.
Your Lordship, kindly leave be given to mention item number 22, which is a commercial site for withdrawal.
Original commercial.
Original site.
Commercial 22, yes.
Yes. The matter has been settled. I'm for the petitioner. Kindly withdraw the matter.
Settled?
Yes.
Very good. Hey, Lekho, Shigiri.
Grateful, Your Lordship.
You are for the other side. Learned advocate for the appellant.
Yes, sir. Yes.
Says that this matter has been settled between the parties out of court. Paragraph accordingly, APOT 112 of 2025 stands disposed of, along with GACOM 1 of 2025.
Your much obliged.
May I be permitted to mention a matter for inclusion, my lord?
Will be included.
Your Lordship's kind leave may be permitted to mention a second appeal, SAT 425 of 2011, which is from the determination of Justice Shobhushachi Bhattacharya.
Yes.
Your Lordship, the second appeal is pending, Your Lordship, and we had preferred a civil...
We have determination.
Yes, Your Lordship. Urgent determination from Monday, Your Lordship.
From Monday?
Yes, Your
Lordship. No, only urgent matters. Why should we take up all matters? We have our own determination.
There is some urgency, Your Lordship.
Oh, I see. You are appearing in the matter?
Yes, I am led by Mr. Ghosh.
Oh, I see. To be mentioned. Monday. Every day we have appellate side. If the original side is exhausted. Let it be listed on Monday. Maybe it will be taken up on Tuesday. To be mentioned on Monday.
My Lordship.
Notify the other side.
Mentioning upon notice, Your Lordship. We shall notify the other side.
I have a matter, including this matter.
Appellate side?
Appellate side.
Give it. Key matter dekhin to.
Any other mentioning appellate side? Side matter. Commercial division में in application item number 1.
One Lordship, I am for the appellant.
That I am opposing.
If I may, Lord.
Before my learned senior starts, may I just raise a point of maintainability, my lord, of the appeal. I know, my lord, I have a very limited right of audience, but this appeal that my learned senior friend has preferred is from an application on my application under order in the nature of an application under order 1 rule 10 of the Code of Civil Procedure, where I prayed for striking of my name from the array of parties.
This is commercial?
Yes.
Commercial.
Is it appealable?
In my humble submission, my lord, it is not. I am just relying on a judgment, my lord. May I kindly hand over?
No, why do you need a judgment? Is it on order 1 rule 10?
Yes, exactly on order. Though the statute, my lord, is here in my submission, my lord.
So your application was allowed?
Yes, my application was allowed. The defendant number 4 was struck out from the array of parties.
My humble submission on this point itself is, since the revisional jurisdiction has been clearly barred by the Commercial Court Act under Section 8, then these kinds of order, we don't have any other forum of redressal. The
So
only
therefore, appeal will lie.
Lordship, the only forum that left is the appeal. Now, moreover, it should be, my humble submission subject to correction, Lordship, is that it should be maybe treated as a latest patent appeal under section 15. Also.
Latest patent is excluded.
This judgment
Because
takes care of that
in this also, I humbly submit that similar kinds of matters are taken up in various courts, and they are allowing other matters like acceptance of return statement, which comes under order 8, which is not covered under order.
22, my lord.
Do not please submit together because Jugalbandi is what we can't.
I waited for his to complete.
My lord, my lord will kindly take paragraph 22, my lord. It deals
22.
with specific FMET, FMET 314.
22, yes.
This is with respect to only this FMET where an application under Order 1 Rule 10 was under appeal. Possibly, my lord, this also takes care of the proposition of an appeal under section 15 that my learned senior friend is canvassing before my lord.
Yes. Not the sections. The section is quite clear.
Aptly clear.
What do you propose to do? You want a rejection or you want to withdraw?
Lordship, if I may, then Lordship, I will pray for some time so that I can go through this thing.
What time?
Around Lordship, I am also relying upon a judgment of the Honorable Delhi High Court. Division bench.
And this is Calcutta High Court.
I understand, Lordship. That is why I'm praying that I'm praying for one adjournment so that I can cover this.
Absolutely clear, sir. This appeal is not maintainable. So we give you the choice of withdrawing this. 136 is always open to you. It's not that you are remediless.
Lordship, then I'll kindly give me liberty of under 136, Lordship.
You need that liberty from us to approach the Supreme Court.
Because that is always
there.
I know.
This appeal is directed against an order dated February 18, 2025, passed by a learned judge of our court in GA Com 4 of 2024, filed in CS Com 669 of 2024, whereby the learned judge allowed an application made by the defendant number 4 in the suit for deletion, company or individual, deletion of his name from the array of parties, array of defendants, under Order 1, Rule 10 of the Code of Civil Procedure. Stop. Now, Order 1, Rule 10 যেখানে বলেছি application under Order 1, Rule 10 করে দিও ওখানে। Sure. Stop. Therefore, the name of the defendant number 4 stands expunged from the list of defendants in the suit. Stop. Being aggrieved, the plaintiff has come up by way of this appeal. Stop. Paragraph. In our opinion, this appeal is not maintainable on a conjoint reading of Section 13 of the Commercial Courts Act 2015, read with Order 43, Rule 1 of the Code of Civil Procedure. Stop. In this connection, the learned advocate for the respondent oblique defendant number 4 has also relied on a division bench decision of our court in the case of Eta Diedebe Odisha such and such 2022 SCC Online Cal 3951, para 22.
22 and 23.
22 and?
23.
Paragraphs 22 and 23. Stop. Paragraph. In view of the aforesaid, learned advocate for the appellant sought leave to withdraw this appeal with leave to pursue such other remedy that the plaintiff may have. Paragraph. Such leave is granted. Stop. The appeal is dismissed as withdrawn with liberty to the plaintiff to pursue such other remedy that it may have in law.
I may be permitted to take the certified copy.
Paragraph. Let the certified copy of the order impugned be returned to learned advocate on record for the appellant upon a photocopy of the same being furnished for being kept with the records. ঠিক আছে বাবা?
Much.
For hearing, item number 2 and 3.
Hearing. I had more or less made my submission on the merits. If I just briefly, 5 minutes, I will recapitulate the points which my learned friend had taken, and I had answered that.
Oh, this is that suit.
Insurance claim.
Insurance.
Rejection of the insurance claim.
That this was not tendered, that surveyor's report was not tendered in
Surveyor's
evidence.
report, 3 points, my lord. Surveyor's report was not marked as an exhibit. Number 2, Exhibit W, that letter of which came from the insurance company, my witness said, yes, the contents are true and correct. And my lord, the second aspect, the police report, police complaint filed by the transporter, marked as an exhibit, but truth of the contents not proved. And therefore, plaintiff has not proved his case. These were the 3 points argument. I had replied regarding the survey report. I had shown your lordship 3 or 4 questions put to my witness on the basis of that survey report.
Hey, shunun ekbar. Such leave is granted. Such leave is granted. The appeal is dismissed. লিখেছো কি বলো? Catch you drunk of the dismissed with liberty. Sorry.
Yes. So, my lord, with regard to the survey report, it will come back to your lordship's mind, my lord. I had shown your lordship the questions put by the defendant in cross-examination to my witness showing the survey report. Not what is this document. Saying that, is this the report of 18 September? First is, are you, if lordship takes page 91, are you aware of any survey report, whether any survey report was filed? Yes. Did you get the copy of the report? Yes. Is this the report dated 18 September which you have disclosed in the proceeding appearing at page number 41? Yes, this is the final investigating cum survey report. Then, my lord, according to the survey report, local transport authorities were not informed. So, not only it has not been merely confronted. Questions put on the contents of the survey report.
Reliance was placed.
Reliance was placed on the survey report. And that is my first point, that if the defendant in cross-examination to my witness places reliance on the document, then the mere fact that there is no endorsement that this document is marked as exhibit will not make any difference, because both the parties accept the existence and rely upon the contents. Number 1. Number 2 is, my lord.
Number 2 is it was part of Exhibit N.
I shall not go into that, my lord. Exhibit N, because what is Exhibit N? When the survey report comes, it says loss is recommended subject to following conditions. You are to produce this A, B, C, D. So I give this survey report and give those documents acting on the survey report. So entirety of that document is marked as exhibit. It is not put to my witness that this document is an incomplete document. You have not given an enclosure to this document. these documents forming part of this letter is not disclosed. So therefore, when a document is marked as exhibit without any contrary case in cross-examination as regards that document is a complete document regarding the contents which is mentioned there. And the first line says we are forwarding the survey report. So my lord, this submission I made with regard to exhibit the survey report. The next document was exhibit W. Exhibit W, I have made my lord detailed submission. Your lordship will recall, I have placed the document. Just 1 second, my lord. Page 181. Yes. It is firstly, my lord, it says that on the basis of the document submitted by you and the relevant survey investigation report. So here also investigation report has been considered. It has been without prejudice concluded. This is not a final determination by the insurance company. It is merely an opinion which is, my lord, clarified by the second observation also. And it says, though the transporter did not deliver the cargo, you neither inform police authorities nor initiate any legal action. So my witness has said, yes, this is true. My witness, it is true because the police report has been done by the complaint, has been done by the transporter. So I did not make the police report, so he has accepted this. The second part is again an opinion of the company. And that opinion is in my favor, I shall say. It is difficult to accept that 3 tankers that certified to carry far less quantity of oil were carrying oil far in excess of its capacity. They don't accept, they don't want to accept this. So what is the wrong if my witness says, yes, this is correct, that we were not carrying in excess of the capacity. Now, my lord, kindly come, last part. Insurance contract, I have come against rejection of claim under the contract. That was my third argument. And I had shown from the insurance contract that it covers all risk, save and except those excluded. You have repudiated the contract. You are saying that means you are saying that my claim is part of the excluded portions.
Burden is on you to establish that.
It is on you to show that I have committed a breach and it falls under the claim, falls under exclusion, nothing else. So what is the exclusion, my lord? Lordship has seen the exclusion is law. In no case shall the insurance cover loss or damage or expense attributable to willful misconduct of the assured. So you will have to prove I was guilty of willful misconduct. You have chosen not to lead any evidence as regards willful misconduct. So, my lord, therefore, your rejection, which is based on exhibit W, does not prove my misconduct. If I am sanguine that my document establishes the case, it can be a case, my lord. It is not necessary that in every case I will have to lead evidence. Suppose a document establishes a misconduct and the document is not truly controverted by the other party, then I can choose not to lead oral evidence. If the insurance company in this case thought so, then, my lord, my submission is there is no document on record which I have accepted and which establishes the willful misconduct. So, therefore, my lord, with regard to page 181, I made my submission. Now, my lord, therefore, my lord, if I may come to the written statement also I had shown to your lordship on the last occasion as regards the accident part. And this, my lord,
Yes.
Well, regarding the accident part, I had placed paragraph 6 of the written statement, where the statement is, it is denied that the consignments were dispatched but could not be traced out and were lost. It is pertinent to mention that complaint regarding alleged loss was lodged to the Burdwan police station after a gap of 1.5 months of incident with no plausible explanation for such delay. Factum of complaint lodged is admitted. Therefore, that transporter's complaint, Exhibit J, is again an admitted position. The factum of the complaint is what is necessary. In this case, truth of the complaint is not necessary for establishing the claim. They could have said here, as I told your Lordship on the last occasion, they could have said here, the vehicle is still running. It is completely false to the core. The complaint is immaterial. This they could have established. But merely saying, after admitting the fact of the lodging of the complaint, saying that the truth of the contents have not been established, therefore complaint cannot be taken into consideration, which may not probably be right in an insurance case. So therefore the only dispute is the time gap in lodging the complaint. Then also, thereafter, the case is violation of duty, which is the perfect defense. Unfortunately, not established. This is the defense, because they, in their pleading, they wanted to come under the exclusion clause. But this has not been established. This is my case. My lord, so they have said in, this is, my lord, paragraph 6 I had placed, and I had also placed the other paragraph relating to the accident, which is, my lord, paragraph 7 or paragraph 8 dealing with paragraph 7 of the plaint. This was placed. There also it is their case, if your lordship will find, that regarding the carrying capacity. Page 44, not possible for the vehicle and the tanker to carry more than the permissible limit. So this is what you will have to establish. And your exhibit W does not establish that. So, my lord, these are my submissions on the rejection of the claim. I just, my learned friend has cited my judgments to distinguish. I'll just briefly refer to those, because the proposition is that in the insurance contract, the breach, I have committed a breach, you are alleging the breach. That is why the contract claim is repudiated.
We have noted those judgments.
Yes, I'll just give you a lordship the paragraph which I am referring to. I will not need not place it separately. Kindly see, my lord, 2016 3 SCC 100.
Yes.
And another thing, my lord, just additional fact is, my lord, accident has occurred. It has to be proved that overloading was the cause of accident, not an accident which may be due to the other vehicle's fault, or my driver's fault, or transporter's driver's fault, whatever it is. So the proximate cause which you have alleged, because only then it will come under my misconduct. You will have to prove misconduct. Misconduct is not accident. That is what, my lord, is also held in this 2016 3 SCC. The lordship will get the brief facts in paragraph 2. Towards the middle, vehicle met with an accident on account of rash and negligent driving of the offending vehicle.
Paragraph 16 is what you relied upon.
Yes, yes.
We have noted that.
Paragraph 13 also, my lord, it has relied upon the Nagaraju case, which is 1996 4 SCC 647. Fundamental breach. Breach has to go to the root of the contract. Paragraph 13 and 14. 14 is Foran Singh case. Foran Singh case I am giving your lordship separately. If your lordship has the copy, or I will give it.
We have.
Yes.
Give the citation, tell him.
এটা প্রথমটা হচ্ছে 2016 3 SCC. Paragraph 13, 14, 15. And finally 16, my lord. So this is, my lord, 2016 3 SCC.
Yes. Oh.
Sixteen is the ultimate ratio. Then, my lord, 1985 2 SCC 574. এটা বলে নেই। আচ্ছা এটা? Yes. 574. Paragraph 12. It is contended on behalf of the insurance company that second appellant did not have a valid driving license. It is the insurance company which complains that there has been a breach of one of the important terms of the contract of insurance, as evidenced by the policy of insurance. And the second appellant, who was shown to be driving the vehicle at the relevant time, did not have a valid driving license to drive the pickup van. Insurance company complains of breach of a term of contract which would permit it to rezone its liability under the contract of insurance. If a breach of a term of contract permits a party to the contract to not to perform the contract, the burden is squarely on that party which complains of breach to prove that the breach has been committed by the other party to the contract. The test in such a situation would be who would fail if no evidence is led. The language and the format in which issue number 7 have been cast by the tribunal clearly casts the burden of proof on the insurance company. Not an iota of evidence has been led by the insurance company to show that the second appellant did not have a valid driving license to drive the vehicle. Kindly come to the next page towards the middle of the paragraph, my lord. On a proper analysis and interpretation of the term of contract of insurance. Just above para 13.
Yes.
On a proper analysis and interpretation of the term of contract of insurance, insurance company cannot escape the liability if A, insured himself was driving, or B, the driver is in the employment of the insured and is driving on the order of the, or he is driving with the words with his permission does not qualify the expression is in the insured's employ. This clause can be properly read thus: any other person with the insured's permission. This ought to be so because the friend can only be permitted if you have the valid driving license to drive a friend. If in every such situation where the person driving the vehicle is not shown to the insured himself or someone in his contract of insurance would afford no protection, and the insurance company having collected premium would wriggle out. So, my lord, ultimately it is the breach has to be proved by them. Then, my lord, the Swaran Singh case, which was referred to in the earlier judgment, 2016, Lordship will take only 3 paragraphs. Paragraph 66, এটা একটু দেখুন তো আছে 2004 3 SCC 297 হ্যাঁ
Paragraphs?
66 69 and 110 4 subpara 4. This is the proposition is same. Once the assured proves that the accident is covered by the compulsory insurance clause, it is for the insurer to prove that it comes within an exception. Then 69 also the same proposition is stated. Proposition of law is no longer res integra that the person who alleges breach must prove the same. Insurance company is thus required to establish the breach by cogent evidence. In the event insurance company fails to prove that there is a breach of condition of policy on the part of the insurance company cannot be absolved of its liability. Then also 70 also your lordship will. And the conclusion is, my lord, 110. Summary. Roman 4, your lordship will see.
Yes.
Court cannot lay down any criteria as to how the burden will be discharged. The point is the burden is theirs. And in this case, my lord, there has been no attempt to discharge the burden. And lastly, my lord, I had relied, Mr. Ghosh has also, I think, showed that 2017 SCC Online Delhi 9511. Which relies upon these Supreme Court judgments, my lord. I am not multiplying. Now, my lord, last point is the limitation, which my learned friend has argued. My lord, kindly see my pleading in paragraph 14 and 15 of the plaint. Section 14, benefit. Here, my lord, my learned friend's submission has been, I have not exhibited the order of the National Commission.
Yes.
Now, my lord, kindly see, there is no dispute to this proceeding. I have specifically pleaded here that by an order dated 31st March, paragraph 15, 31st March 2008, National Consumer Dispute Redressal Forum has held that the plaintiff will be entitled to obtain benefit of Article 14 of the Limitation Act in the event it files a suit. Proceeding is named, order is named. Kindly see the written statement. Paragraph 16 of the written statement, page 50. Save and accept what are matters of record, all statements are denied. So, if it is a matter of record, this order dated 31st March 2008 is a matter of record, it is not denied. If there is no order passed on that day, or there is no order before the tribunal, it cannot be a matter of record, insofar as the defendant is concerned. For the defendant, the pleading has to be, there was no proceeding. Then, my lord, may I submit this, my lord? If it is a matter of record, if you yourself, you are saying that order dated 31st March is a matter of record, is it necessary to be marked as exhibit, or court is competent to take cognizance of a matter of record while the hearing proceeds? What is a document which is
Was
exhibited?
this order before the court?
Yes, but I will produce it before
Maybe,
your lordship.
maybe not exhibited, but
Maybe not exhibited, may not be part of my document. Judge's brief also.
where from you show that this was before the court? Maybe this is erasing denial. This is no
But I cannot show except my
erasing denial. There is no need to prove it.
But it is part of the judgment.
Is it order of NCDRC? Is it not a public document?
It is an order of a tribunal.
Is that a public document? Whether it requires specific proof? Evidence একটা কোথায়?
(74)(1) Roman 3, if your lordship sees.
Tribunals.
Yes.
Records of tribunals.
Yes.
So a certified copy need not be proved
Yes.
of a tribunal's order or any part of tribunal's record.
And the court has taken cognizance of that while dealing with the issue of limitation. The objection is could not have taken.
This is the decree of this court. Records of the suit have been produced before us. Did we call for it? We can't remember. I was standing in a good.
No.
Hey,
The suit. So there is no usual calling for records in other matters.
no, we'll ask them to produce the suit records before us.
Yes, the judge's brief of documents are there. It is included, Minor.
It is included.
Yes, because from the judge's brief it was marked. So
no, so NCDRC order is there in the judge's brief.
Minor, in the judge's brief of documents, the document disclosed by the plaintiffs are there. But I do not find, subject to correction, any certified copy which under section 77 of the Act of 1872 will prove the order. 77, kindly have a look at that.
So are you in a position, Mr. Sen, to tell us if certified copy of that order was produced in whichever manner, as part of judge's brief, loose order? This is separate from the question as to whether it required proof at all. Because there is no real denial. This save as what appears from record, evasive denial.
What I find from the judgment, my lord, frankly speaking, I cannot. It's quite some time.
You appeared before the.
Yes, I have appeared. Copy the judgment. I think it is pre-COVID.
Would it be of any assistance if we call for the records and you can go through the records and see if such a copy is there? That would solve. এই তুমি রেকর্ডটা আনাও না, হ্যাঁ রেকর্ডটা আনাও। You have more or less completed.
Yes.
Mr. Ghosh, you in reply.
Judgment order 41 rule 27 that I will give you, Lordship.
In reply, you could conclude today also or on Monday, whatever. But by Monday, this should be concluded.
If this is similar up to this, my learned submission is I can conclude today.
Very well. Then let him cite one more judgment, as he said.
2012 8 SCC 148.
Oh, I see. Order 41, Rule 27. They have an application.
They have not pressed that application, except that at the concluding part, it was said that the tankers are still roaming around. And they have got some document from the registration authority. But this is not a document which has come after the suit. If it is a case of willful misconduct, that's what I said. So in their defense itself, when they are saying that I'm guilty of willful misconduct and the complaint is a vague, completely frivolous complaint, then they should have proved that on that during the trial of the suit itself. And my lord, it is a reply to an information. Again, it is not a primary document. There are primary documents which are available to show that the vehicle is there.
No, I have never said that this is evidence. I say that if it is allowed, then it will have to prove following section 65B. It can't be evidence at this stage.
Very good. Well, so therefore, even before your lordship also, that evidence is not disclosed. Anyway, I say, my lord, kindly take only page 148, paragraph 36 to 41. Kindly see paragraph 36 onwards, my lord. And my lord, 4127 power exercise of power comes after they overcome the hurdle of explaining why not during the trials. Those first three grounds have to be satisfied. Then questions the discretion of the court, whether it is necessary to at all for the purpose of the appeal. So here my submission is the first condition itself is not fulfilled.
Is that right? Or
kindly see. Provision department. First is that parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary appellate. But if the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted, or this will not AA, parties seeking to produce evidence, additional evidence, establish that notwithstanding exercise of such evidence was not within his knowledge. So that is the precondition.
this is all or.
Yes, my lord. Or.
Look at the third or.
Appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. I appreciate, my lord. But your lordship will kindly see.
No, but this must have been interpreted by some court.
Yes, my lord, this has been interpreted here, my lord. Your lordship will come to 36 onwards.
Yes.
37, 36, my lord, your lordship, is the general provision. Kindly see. General principle is that appellate court should not travel outside the record of the lower court and cannot take any evidence in appeal. However, as an exception, Order 41, Rule 27 enables appellate court to take additional evidence in exceptional circumstances. Appellate court can permit additional evidence only and only if the conditions laid down in the rule are found to exist. Parties are not entitled as of right to admission of such evidence. Thus, the provision does not apply when the basis of the evidence on record, the appellate court cannot pronounce a satisfactory judgment. Can pronounce a satisfactory judgment. The matter is entirely within the discretion of the court and is used to be used sparingly. Such a discretion is only a judicial discretion circumscribed by limitation in the rule. Then, my lord, 37. Appellate court should not ordinarily allow new evidence to be adduced in order to enable a party to raise a new point in the appeal. This is not a ground in the written statement. Similarly, where a party on whom the onus of proving a certain point lies fails to discharge the onus, he is not entitled to a fresh opportunity to produce evidence, as the court can in such a case pronounce judgment against him and does not require any additional evidence. So these conditions he cannot fulfill. Under Order 41, Rule 27, appellate court has the power to allow a document to be produced and a witness to be examined, but the requirement of the court must be limited to those cases where it is found it is necessary to obtain such evidence for enabling it to pronounce judgment. This provision does not entitle the appellate court to let in fresh evidence at the appellate stage where, even without such evidence, it can pronounce judgment. It does not entitle the appellate court to let in fresh evidence only for the purpose of pronouncing judgment in a particular way. In other words, it is only for removing a lacuna in the evidence that the appellate court is empowered to admit additional evidence. It is not the business of the appellate court to supplement evidence adduced by one party or the other in the lower court. Hence, in the absence of satisfactory reasons for non-production of the evidence in the trial court, additional evidence should not be admitted in appeal, as a party guilty of remissness in the lower court is not entitled to the indulgence of being allowed to give further evidence under this rule. So a party who had ample opportunity to produce certain evidence in the lower court but failed to do so or elected not to do so cannot have it admitted in appeal. Inadvertence of the party or his inability to understand the legal issue involved, or the wrong advice of a pleader or negligence of a pleader, or that the party did not realize the importance of a document, does not constitute substantial cause within the meaning of this rule. The mere fact that certain evidence is important is not in itself a sufficient ground for admitting the evidence in appeal. And 41 also, especially substantial cause has been.
We've seen.
So, there is no cause, my lord, here for letting in the.
That is all.
Well, there is one judgment on without prejudice, but I don't want to multiply it. Without prejudice,
Give us anyway if you have it.
2006, volume 12, SCC 673. Kindly come to paragraph 42. Only because the expression without prejudice was mentioned, the same, in our opinion, by itself was not sufficient and would not curtail the right of the insured to which it was otherwise entitled to. The expression without prejudice may have to be construed in the context in which it is used. If the purpose for which it is used is accomplished, no legitimate claim can be allowed to be defeated thereby. These are mine. And my lord, I had already placed Exhibit N, which records that the value per transit has been enhanced by 15 lakhs. That is why the learned judge, considering the same, has said that it is within the insurance limit also.
Let kindly take the judgment one. The chart of the exhibits mentioned in the judgment. Page 204. Paper book.
দেখিনি কোথেকে দেখেছি জাজমেন্ট জানি না দেখি তাও না
Kindly come to item serial number 14, exhibit N. Page 206 of second volume.
1 second, Mr. Ghosh, 1 second. না এটা থেকে দেখিনি yes
Serial number 14, exhibit N. Description is letter dated 15th October 2004 by the plaintiff to the defendant number 1 with regard to claim for such and such. A single letter is mentioned. Now kindly look at also, because if your lordship kindly look at, say, for example, serial number 17, exhibit Q, or the exhibit R, several letters are mentioned, exhibit wise. The Honorable Judge was very particular about the letters and the descriptions thereof. Now kindly take the page 153. Page 153. Miller, kindly come to page 153, capital A. This is a type copy. Is a letter addressed to the insurance company from the plaintiff at page 154A. First minute paragraph, we forward herewith the final survey cum investigation report along with the bill, etc. So it is the plaintiff who is, according to the letter, is forwarding, not a letter written by the insurance company forwarding the report. I can understand that somebody has given me a letter, the defendant number 1, enclosing a copy of the valuation report. So it has come as a matter of course, as an annexure to that letter or enclosure to that letter. It is not like that. So it is a letter of the plaintiff and the letter only that has been exhibited. The letter itself does not mention in the second page, enclose as above. Kindly have a look at page 154A. Usually, when something is enclosed to a letter and those documents are mentioned in the letter, at the bottom of the letter it is written enclose as above. That is missing here.
Did you give any reply to this letter?
There are various correspondence regarding the claims. I'll have to check up whether this particular letter has been.
Ask him to check up.
May I proceed, Miller, in the meeting? Now, Regarding the surveyor report, from the judgment, it is clear that that has not been tendered in evidence as exhibit. My submission was a little bit more. Even if it was tendered as an exhibit, marked as an exhibit,
Contents not proved.
Contents
Truth
not-
of the contents not proved.
so
We have
that has
noted
not
that.
been denied.
We have noted that.
My lord, that has not been denied. I need not, my lord, explain that again. But my learned friend has said that, look, you have put questions on the report to the surveyor. That by itself does not prove the truth of the content, because I have put questions to the plaintiff. It is not, my lord, there are procedure or provision of evidence act. You give notice to produce. He should produce it. If he produces it and I put questions, what will be the effect?
But Mr. Ghosh, if the tenor of your cross-examination on that report shows that you are actually accepting that report or whatever is stated therein, would the court be very unreasonable or acting unlawfully in taking into consideration the contents of the report?
My lord, in my most respectful submission,
You need not have put any question on the report at all. You don't recognize the report. That is one thing.
my lord,
But
I
you
put-
refer to the contents and you cross-examine him on that.
may I look at this issue, my lord, from this angle? The report is given by the surveyor.
Yes.
But I'm sorry, my lord, I'm going to
Your surveyor. Your surveyor.
our surveyor.
Surveyor is not our person.
I've been instructed, is supposed to be an independent person. Let us appointed by us. Let us kindly take section 60 of the Evidence Act.
My learned friend is on this document, and in response to your lordship's query regarding reply, I just want to show one exhibited document which they say that the survey report they have received. Page 161, capital A. That is a typed copy. Refer to our previous letter.
No, there is no confusion about the existence of the report, survey report. I cannot deny that there was a such survey report.
No, you just now raised a point that the letter dated 15th October
Yes.
doesn't say that enclosed as above. So it is possible that the survey report was never sent. That is what he is answering by showing. Admittedly, you received the survey report. That is all he is saying.
Maybe.
Yes.
But question before your lordship is whether the truth of the contents of the survey report has been proved. Kindly take section 60 of the Evidence Act. My lord, oral evidence must be direct. Oral evidence in all cases, whatever be direct, that is to say, kindly come to subclause 1. If it refers to a fact which could be seen, it must be the evidence of witness who says he saw it. If we go by direct evidence first clause, then it is not the evidence of, there is no evidence of surveyor. Kindly come to subclause 4. If it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of the person who holds that opinion on those grounds. Expert's opinion. If you take surveyor to be my own person, then he must have seen it personally. He should give evidence to prove the truth of the content. If you take him a bit in a different stand, just like an expert. He has examined the case and gave his opinion in the survey report. Then he must be examined. And it is for the plaintiff to examine him.
Serious departure.
This basic concept of Evidence Act cannot given a go by.
Yes.
So I think, my lord, whether or not the surveyor report was, I should say, accompanying that letter, Exhibit 10, and whether or not the defendant number 1 accepted that it had received the surveyor report, that fact can only relate to the existence of the document, to which I have never raised any objection before the Lordship. I can't. But the main question remains, in view of section 60, subclause 1 or subclause 4, the truth of the contents of the surveyor reports have not been proved. And without that evidence, my learned client, the plaintiff, is not entitled to get any compensation on or in respect of the tanker which has, according to them, has undergone an accident. Now the other part, the lost part, 2 tankers. Now again, we come back to section 60. That is the basic part. We seldom follow. I'm making it clear, we seldom follow this principle, basic principle. Plaintiff comes and says, though in print sometimes it is written that it is verified, now affirmed these days, that look, this part, my personal knowledge, this part on the basis of the information received from so-and-so and believed by me to be true, and this part is on the basis of the information received from the documents lying at such and such place and believed by me to be true, and this is my submission. Now, that Exhibit J, that letter that of the transporter, that transporter has filed the FIR. Now kindly again look at section 60. Yes, I'm arguing on point of law. I'm entitled to do.
It's only, Mr. Ghosh, in reply, what ideally you should do is deal with his cases, which you have already done.
Yes, but when he says a proposition of law, this is the proposition of law. Kindly look at section 60.
These days, nobody follows that principle, that in reply, nobody, I mean, no case. And we also don't stop.
No, then I should stop. If I
No, please.
I thought that this is a point of law from his submission. Kindly look at section 60.
Yes.
Subclause 2. If it refers to a fact which could be heard, it must be evidence of a witness who says he heard it. Hearsay evidence. If it refers to a fact which could be perceived by any other sense or in any other manner, it must be evidence of a witness who says that he perceived it. Your Lordship will find that in case of cases of regarding claims arising out of lost cars, it may not happens regularly. Insurance claim for lost cars, not faced with an accident, lost cars, one has to get some sort of evidence, because in most of the cases, your lordship will find the fact that the car is lost has not been disputed. It has been proved. I should say it has been proved. How one can prove the loss of car from the final report of FIR? They must show something. It could not be traced. That must come from an authority. And for that, one has to prove the records, certified copies. That's all. Now, if they discharge their burden, then all the judgments your lordship will find regarding insurance claim, where insurance company has raised, my lord, the issues regarding the fault on the part of the insured, breaches committed by the insured.
Yes.
And section 77 is of the Evidence Act is the answer. How could they prove either limitation or this one? Kindly have a look at section 77. 76 is the certified copies. 77, such certified copies may be produced in proof of the contents of the public documents or part of the public document which they purport to be copies.
Yes.
That is not there. This was precisely my submission without mentioning the section. If the regarding limitation, if certified copy was there, I wouldn't have uttered any word.
We will also have to consider, anyway, we will, whether your paragraph dealing with para 15 of the plaint amounts to denial. That we'll have to consider.
Subject records. It is qualified by.
If we hold that this is no denial or evasive denial, then if we hold it's an admitted fact, then the question of proof doesn't arise.
Yes. Savers will appear from records if it has got according to the court, it is really no denial at all, evasive denial. Then matter ends there. This part won't come.
Correct.
But whether it amounts to that or not,
Yes,
your lordship finally
we'll have to consider.
Because section 14, one has to consider. And so far as the additional evidence is concerned, I again make it clear that we have stated in our application that what has actually happened, we came to know it after the judgment. That is why it could not be proved in the suit. Now, question is the belief of court, whether your lordship will accept that this is correct or not. But as a lawyer, I must say, even if your lordship accepts that here, that does not by itself, that order would prove the documents. Because those are computer generated copies. So one has to take 65B of the Evidence Act. One has to prove that. These are my responses.
The way it has been denied,
doctrine
of non-traversal.
Hearing is concluded, judgment is reserved.
This is next matter can be done after.
This
Next
is in
matter,
this item number 3, man.
Next appeal.
Next.
Can be?
Item number 2.
Can be taken up later.
Yes. We have no
I am
problem.
not there.
After you are not there. After we have decided this, let it go out of the list for the timing then. Why should it run in the list then? 2 নম্বরটা order করো খালি। 2 নম্বরটা order করো।
এই appeal number
Hearing is concluded, stop judgment is reserved. আর 3 নম্বরটা একটা order করো। Let this matter go out of the list for the timing with liberty to mention. এইটাকে
APD number 1 is being heard now. কোনটা দেখেন? Item number 3. APD number 1 is being heard. Grateful.
No.
11 for sure. No, sir, 11. No.
My lord, I appear for the appellant, Lordship. I'm led by Mr. S.N. Mukherjee and Mr. Ratanko Banerjee. My lord, this is the Vodafone IPRS matter, my lord, which is ready for hearing.
both of whom are not available today.
My lord, I'm only praying if Lordship could kindly consider us, we've spoken with Mr. Mukherjee because he'll have to argue the appeal.
Yes, tell us when.
11th August, if it could be, Lordship.
The only thing is, my lord, 11th August, let it, my lord, be recorded. But at least on that day, they should not ask.
We are recording it.
That their prayer, my lord.
Number 4 or 4, 5, 6.
5, 6. All three matters.
But separate orders. তাই তো? Accommodation is prayed for on behalf of the appellant
Lordship.
on the ground of non-availability of learned senior counsel. Stop. Mr. Shorkar, learned advocates, submits that requests that this matter may be taken up on August 11.
Lordship.
You are August 11? Monday.
2025.
Stop. Let that be so.
Lordship.
My lord, on that day, my lord, this prayer will not be renewed. Because, my lord, I'll tell you, Lordship, there is some urgency because
You recorded it, Mr. Rashidari.
11th August.
Yes, we've noticed you.
Yes, my lord, the rushing in otherwise, my lord, would have failed its purpose, my lord.
Same order 4, 5, 6. 11th August. Now check your diary.
Yes, my lord.
Grateful.
Appeal from orders. Item number 7.
এই item 4টা Vodafone versus blank আছে কেন? কে? 4 আর 5 Vodafone versus blank. এবার কিরকম?
Indian performing rights.
Should be there in the list.
Lordship.
এরকম ছাপায় নাকি? ঠিক করে পরের বাজারে পুরো নামটা আসে। তারপর ফাঁকা মাঠে গোল দিয়ে যাবে, আদার সাইডে কেউ নেই।
Will not be possible, my lord, in the presence of my lord, Mr. Rajul. Item number 7. From order.
নেই কেউ, নেই তো।
Supposed to conclude the hearing too.
They had started arguing.
Yes, they are started asking.
Who was appearing? Passover.
Item number 8 and 9.
I am praying for not today, my lord.
Not today.
Item number 10.
For the respondent, my lord. Section 37.
Passover.
My lord.
Item number 11 and 12.
My lord, I am.
Opposing.
They have made an
Appellee.
application under order 41 rule 27, my lord.
That will be heard with the appeal.
My lord, the lordship gives a direction for filing affidavits.
Oh, you
if
want to
act-
file an affidavit?
Yes, my lord.
এই দেখি কোথায় application-টা? In which one? There are two appeals. In both appeals.
No, my lord. Only one. Queen.
Kunenagal, my lord, I am appearing for Kunenagal.
You have made an application under
My lord, my lord.
Order
My
41.
lord, my local counsel would be there. She is having the original copy. They served the
Are you
opposite party.
Are you by any chance are you inside a motor car?
No, no, my lord, I am in my office only.
Your office, all right.
But some other, I think, counsel is also appearing. He is
No.
not from our office.
Sir, nobody is there. Nobody is there on your behalf. The respondent is there.
My lord, kindly pass it over. My local would appear.
Give
my lord.
directions for affidavit. That will not harm my learned.
That's right. They want to file affidavit. Let them
No
file.
issue, my lord. No issue, my lord.
Another gentleman is appearing virtually. If you
Yes,
are,
Manoj. I'm appearing for this order number 2, Manoj. In the
where are
application.
you? Where are you?
Manoj, I'm in the court. Manoj, I'm in Delhi, in Supreme Court. Manoj, the local counsel must be there. I'll just coordinate with him to be present over there.
কি দিচ্ছ? Application-টা চাইলাম. But in the list there is no application. Miss Mukherjee,
My lord, but
in
that
the list there is no application.
served upon us.
Huh?
It was supposed to be there. It is served upon us.
Served on you.
My lord, kindly pass it over. My local would appear with the application.
Your lordship will take it up on Wednesday, my lord.
Yeah. Wednesday. Why not Monday?
Monday, I stay in a place where I will not be able to come out of my house. If your lordship allows me to log in.
No. Wednesday, sir. Instruct your local counsel to be here on Wednesday.
Please,
and
my lord.
find out, because it appears from the court records that application is not there in
My
the court records. Very well. Wednesday.
Highly grateful, my lord.
Number 13.
Cholo.
Number 14.
For the petition, I am being led by Mr. Jayanta Kumar Mitra.
For appellant?
Yes, ma'am.
Cholo, not today.
Thank you, ma'am.
Item number 15. Item number 16 and 17. Item number 18.
I'm praying for not today. I'm for respondent number 1. Grateful, your lordship.
Item number 19. Item number 20. Item number 21.
Well, my advocate on record has one copy of the reply. He has, for some reason, misplaced another copy. If it can be filed within the course of the day. If I can file one copy now within the course.
No, file together.
My lord, as my lord deems fit. My order was passed on 28th February 2020. The pandemic intervened immediately thereafter. And there was some communication gap between the client and the learned advocate on record who was representing my client at that relevant point of time.
Is that a ground for review? There was communication gap between you and your...
This is the ground for delay, my lord, not review. Review, I cannot.
What is your ground for review?
My lord, will kindly take up my memorandum of review, my lord. What had happened, the plaintiff number 2 had died, my lord. He should have been substituted. He was substituted, in fact, by his legal heirs. But the only difficulty is that, my lord, the shares of the legal heirs of
this review application is at the instance of whom?
My instance.
Plaintiff.
Defendant, man.
Defendants.
Defendant number 2, my lord.
Yes.
Defendant number 2, my lord.
Yes.
After the plaintiff number 2 had died.
Plaintiff number 2.
Plaintiff number 2, my lord. Plaintiff number 2 was one Masood Ali Mullik, my lord. He died, leaving behind 3 legal heirs, namely Nazia Mullik. Nazia Mullik is his wife. Mariam Mullik and Maslina Mullik are his daughters. In accordance with the Muslim law, my lord, the I'm extremely sorry. In accordance with Muslim law, my lord, the wife should have been given 3/24th share of his property, and when it comes to the daughters, they should have the residual portion has to be divided between.
We have not followed. You said after plaintiff number 2 died.
My lord.
You are for the defendant number 2.
My lord.
So what plaintiff's branch gets, how are you concerned? And even if there's an error in the order. An error in the order under review is not a ground for review. Go up to the Supreme Court. There are very limited grounds for review.
The only thing, my lord, that way the preliminary decree of partition does not state the exact shares of these persons, my lord, for which the entire shareholding of all the persons gets affected. That is the only thing, my lord. That is the only thing. That is the only ground of review, my lord. And in fact, only there are 5 grounds of review, not much, my lord. And
then go for review of the trial court's decree.
Because this has been upheld by an appeal court, my
we'll
lord.
grant you liberty.
যেটা
বলছে ট্রায়াল কোর্ট ডিক্রিতে সব পার্টি শেয়ার
the decrees, this is only the memorandum of review. I can come up, I can.
Saying that in the preliminary decree, the share of
I can, if my lord deems fit, I can come up with a compilation of documents, my lord.
We'll grant you liberty.
My lord.
Issue. We'll condone the delay, sir. We are not entertaining the review. We are not entertaining the review application. If they are entitled to go for review of the trial court's decree, they'll go.
At this stage. At this
Whatever, yes.
My lord, in accordance with law. One submission. The matter was filed in the year 2002, and thereafter, one plaintiff number one died, plaintiff number two died, and next plaintiff defendant number three died, and they are continuing the case filed to linger the case.
Sir, we are not touching the decree. We are not entertaining this application. Why are you making submission?
They are court where this matter is pending.
Actually, he is of the view that is a question that dismissal of the appeal by the Honorable Division Bench.
You want expeditious disposal of the suit. What do you want? If you think there is undue delay in disposal, go under 227. You know why should we advise you?
Matter is appearing in this matter, and the trial court is only for this application.
We are disposing of this. Application for condonation to now. Okay. You file the reply in course of the day. Mr. Ghosh.
My lord.
Reply in course of the day.
In the course of the day, my undertaking may be recorded.
On the undertaking of learned advocate on record for the review applicant to file the affidavit in reply in connection with the application for condonation of delay, comma, in court, in course of the day, comma, this matter is taken up for hearing. It can't condonation. Yeah, appellate say that the original say can go. Paragraph. Although we are not
সে তো ও যদি এটা না করে রিভিউ ফাইল
19, and taking a lenient view of the matter, comma, in the interest of justice, comma, we condone the delay. তারপরে GA1 is disposed of. Paragraph. The paragraph na. এবারে ওই review to now or read whatever it is. This review application is directed against a judgment and order dated February 28, 2022, passed by a coordinate bench of which one of us was a member, bracket, paragraph, comma, bracket close, comma, whereby it was whose appeal? Plaintiff's appeal.
The defendant number 2's appeal, my lord.
Sure.
My lord.
Whereby
It was
the
my
appeal of the defendant number 2 in the concerned partition suit was dismissed, and the preliminary decree of the learned single judge of our court,
my lord.
learned single judge, was affirmed. Stop. The defendant number 2 has now filed this review application, saying that the preliminary decree of the learned decree passed by the learned single judge does not specify the shares of all the parties, which is creating great difficulty. Stop.
My lord, one
Sir, why are you interrupting? Sir, why do you interrupt when somebody is dictating judgment? কিছু বোঝেন না এরা যে চেইন অফ থটটা হয়ে যায়। কি বললো? Paragraph. We see no reason to review the order dated February 28, 2020. Stop. None of the grounds mentioned in Order 47, Order 47, Rule 1 of the Code of Civil Procedure has been made out. Stop. If the appeal court has erroneously affirmed the preliminary decree of the learned single judge, comma, such error can be corrected by a higher forum. Stop. Review is not the course of action to be taken. Stop. Paragraph. We dismiss this review application, reserving liberty to the review applicant to approach the learned single judge for an appropriate with an appropriate application if he is entitled to do so in law.
In that case, only one submission, kindly, if they choose to file the review application, kindly give some time limit. Otherwise, they will take indefinite time.
And what will do?
In the event the review applicant decides to approach the learned single judge, comma, that should be done within 4 weeks from date and not beyond.
And all the points are kept open.
Yes. We needless to say that we have not gone into the merits of the case at all.
Grateful. Great. Order dated 28 February 2020. কত আছে কি আছে মেনশন করে দেখে আপগ্রেড যদি করে ডাউন একটা রিভিউ এর তেলাপাকে করে দিয়েছে দিয়ে গেড়ে বসে আছে জায়গায় eviction order pass appellate authority পিপি অ্যাক্টে appellate authority ভাগিয়ে দিয়েছে এখানে রিভিশনে এসেছিল রিভিশন ডিসমিসড যেটা রিট করলো সেটাকে ডিসমিস হলো মুখ হলো দিয়ে একটা রিভিউ বাকি ফেলে রেখে দিয়ে জায়গাটা গেড়ে বসে আছে takes up listed matters, my lord. May I make a humble prayer in respect of listed matter? Item 20. That sport trust land lordship may recall.
Yes, what?
They are holding the land in the garb of a review application. Eviction order passed. Appeal preferred.
What do you want, Mr.
My lord, precedence on the next date when lordship would be assembling on the next day.
Let us see. You have told us, let us see.
It's for a long
Yes,
time.
pending. What can be done, sir?
My lord, I know, my lord, the bench is not regular. If some precedence can be given.
Let us see. Allow us to Daku.
Applicant matter item number 124. My lord, this is the matter lordship will kindly recollect. Lordship,
Saraswati Press.
Saraswati Press.
My lord, I appear for Saraswati Press. My lord.
Now, lordship kindly sees the lordship's last order dated 5th March 2025. In the written notes of argument,
You wanted to file additional written note.
so we wanted to file additional written notes because the state in its written notes had taken completely different points.
We have granted you liberty.
Yes, my lord. So these are the written notes which we prepared.
File the notes.
Lordship.
To be very frank, it's been quite some time. What we propose to do,
my lord,
Mr. Mukherjee, we propose to go through the notes.
Lordship.
On the next day, 15 minutes, just summarize the entire case. Once we have gone through the notes,
we will.
Yes, just summarize the case and we will reserve judgment then.
And I'm led by Mr. Mitro.
Yes, we remember everything.
Lordship.
Yes. So once we go through the notes, it will all come back, hopefully.
My lord, may I seek an indulgence, my lord?
Our first note contained only the arguments which are advanced during oral hearing.
Additional written notes of argument filed on behalf of Free India Dry Accumulators Limited in terms of liberty granted by us by our order dated March 5, 2025, be taken on record. Paragraph. Let these matters be listed once again on August 1, 2025, under the heading Specially Fixed Matters.
Lordship, may it be August 1, I am not there.
You're not there?
In any...
August 8.
August 8.
That's a Friday, 2 o'clock.
My lord, may I seek an indulgence, my lord? My lord, appellant be directed to circulate the copy of additional written notes filed today, my lord.
Where are you? Why are you not in court?
My lord, I have an injury in my leg, my lord.
Oh, what happened? Fought with somebody?
No, no, my lord. Shoe
When?
bite, my lord.
Shoe bite?
Yes, my lord.
Give him a copy.
Lordship, we will. And me also. I have told.
After all, he has been bitten by his shoe. Shoe bite. 8th August.
I am appearing on behalf of the respondent number 1 and 2 on behalf of the state respondent, Learned Advocate General leading me, and appellant in item number 2 and 3.
So please inform him this will be listed on 8th of August. Just for an outline, because it has been a long time.
Will it be Lordship's pleasure to keep it at 2 p.m.?
PM only.
2 p.m. Much obliged, madam. Because then only otherwise we do not know Friday.
No, 2 p.m. First half will be the regular bench. This is a broken bench.
Lordship.
Deeply obliged. Lord, it is Lord, another name of Boloram, another name of Lord Boloram.
Oh,
হলোকর্ষণ থেকে
হলোকর্ষণ, from হলোকর্ষণ সংকর্ষণ. Very good.
আমি
নম্বরটা হচ্ছে যেটা আমরা যে কাগজটা ধরে আর্গুমেন্ট চলছে 7 নম্বরটা আগে প্লিজ 5 to 11 is the same matter. My lord, kindly take it up item number 7.
Illogically, remember of this matter, that is by the advertisement on the flyover.
Oh, yes.
That matter, Your Lordship, hard matter at length. Both of us, my lord, only at the stage when I also prepared my written notes of argument.
Mr. Ghosh.
I will not hear, my lord. I said to my learned junior, because, my lord, it was, my lord, long drawn, my lord, argument has been advanced, my lord, we have prepared a written note. Even go through, my lord, overlook just look into that matter. Even if he feels that anything, because ultimately it comes down to a short point. Because you can remember, my lord, that when the question came, my lord, he said, but the land utilization charges. That, my lord, on the street, the flyover is there, their advertisement is given by the HRBC.
Let us tell you, Mr. Ghosh. Firstly, we have different determinations.
But I know, my lord.
My brother's determination is very heavy. My determination is also very heavy. Now, to break up like this and to take up all these matters will be very, very difficult for us. Allow us to release, go
But I have prepared the written note. You will also next day, you
No, now we'll first have to give priority to the first 4 matters.
But you will also give it that. Then you also, because we are waiting. I mentioned on some of
Then
the
wait for some more time. We'll take the item.
My lord.
So let these matters be then listed. My brother is going on circuit from 11th after that. এটা কি কম্বাইন অর্ডার আছে না আলাদা আলাদা অর্ডার আছে?
আলাদা আলাদা
let this matter শোনো
আলাদা
An appeal from Justice Sampasad.
My lord? Yes, my lord. My lord remembers, my lord.
Let this matter be listed again on তুই ফিরছিস কবে? August 29. August 29. বুঝেছো? Stop. On that date, the parties will be at liberty to file written notes of arguments.
Kindly pass an order for analogous hearing of the 5 to 11, man.
Same order korbe file. They'll be listed together. Separate orders. Same order.
One matter to name.
5, 6, 7, 8, 9, 10, 11. 7 matters. 7 fees.
Orders, my lord.
Same order in all cases. Well, one matter has not been listed. I will give the number to your losses officer.
শুনুন একটা বলছি সিমিলার ম্যাটার লিস্টেড হয়নি, নম্বর দিলে এর সঙ্গে সঙ্গে দিয়ে দেবেন।
বলছে আনতে
সেটা নিয়ে নেবে, কিন্তু একটা আরেকটা অন্য অ্যাপিল আছে বোধহয়, ওটা দিয়ে দেবেন এটার সঙ্গে, দিয়ে দেবেন এটা কপি।
কি দেবো অ্যাপ্লিকেশন মানে এটা ফাইল করা আছে তো, হ্যাঁ ফাইল করা আছে, ওটা নাম্বারটা দিয়ে দেবে।
এটা আমি নিয়ে নেবো।
ফাইলটা পাচ্ছেন না? ও আচ্ছা, অ্যাপ্লিকেশন তাহলে একটা কপি করে দিয়ে দিও, বুঝলে? অ্যাপ্লিকেশনটা নাকি পাচ্ছে না, ফাইলটা পেয়েছে। ঠিক আছে, আচ্ছা ঠিক আছে, দিয়ে দেবো। এই মনীষা মনে করে তাহলে দিয়ে একটা ফিল করে
তুই উইকেন্ডে এখানে?
ঠিক আছে। দেখো বেরো করছো কেন? বের করতে হবে, আমার আর্গুমেন্ট হবে দুটো আমরা একসঙ্গে সব
কি হলো দেখেছো?
12 and 13.
The 12 and 13, my lord. Lordships, kindly, my lord, see the order dated 5th.
Last order.
Yes.
Lordships, may I respectfully invite your Lordships' attention to the last order dated 5th March 2025. My lord, my learned senior friend.
আপনি কি আজকে ফাইল করবেন?
হ্যাঁ, ফাইল তো সব তো হয়ে গেছে, লেখাই তো ফাইল করতে বলাই আছে তো।
না, আমি লাস্ট দিনে আপনি ফাইল করেননি।
না না, জজ সাহেব সেদিন লিবার্টি দিয়েছে, আমি ফাইল করতে চেয়েছিলাম, নেননি আর কি।
Because you were already ready তো ছিল।
জজ সাহেব নেননি বলে একই দিনে নেক্সট ডেটে ফাইল হবে। তাই তো অর্ডার আছে, লাস্ট মিনিট অর্ডার আপনি পারবে না।
Yes.
There was
not ready.
Lords.
Two appeals are there, one by the state, another by a.
Yes. Ideally, we want to release this matter. In that event,
kindly go
Mr. Vera, we have our other determinations.
I know, my lord.
You will have to then wait for some time.
Yes, we will wait, no problem.
You can file your written note.
Yes.
We will list this matter once again on a particular date.
Yes.
When you will just give us an overview.
As short as possible.
Yes.
I think I will conclude within 15 minutes.
Yes, 15 minutes, 15 minutes.
Lordship, no problem. No problem.
Right?
Lordship.
File your written notes.
Yes. All right. This is for this.
We had said short written notes.
No, written notes are
No,
the
written note is very
judgment.
short.
Judgment.
The judgments
Judgment is relied upon have been copies has been supplied.
written notes are very short, Lordship.
Written notes.
Acha,
Given the judgments also.
And Milord, so far as this is my appeal. Two appeals are there. First judge, second judge, honorable presiding judge, second judge. ওটা গভর্নমেন্টের অ্যাপিল, এটা আমাদের অ্যাপিল 914। But written notes are not so ভালো।
হ্যাঁ
And এটা হচ্ছে I'm just Milord আর এটা হচ্ছে 91
আমাদের অ্যাপিল
হ্যাঁ এটা হচ্ছে 91 Milord, copies have been exchanged between
yes
you are filing separate written notes in the two matters.
Yes.
One is my learned senior friend's appeal. We are filing a written. That is 914. And FMA is ours.
Really, scope are to some extent different. That's why we have filed an appeal. So we have filed separate written notes into it.
Written notes of arguments filed on behalf of the respective parties in the two appeals are taken on record. Paragraph. List these matters once again on আগেরটা কতই দেখেছিলেন
29th your lordship has picked
29
other matters, Mr. Ghosh's matter.
Then next week, keep it on the 5th September is a holiday. 12th September.
Very well, lordship.
On September 12, when learned advocates for the parties are requested to recapitulate the material facts and points involved very briefly.
Bird's eye view.
Bird's eye view. We'll read your notes and come so that it will not take.
Grateful.
I'm grateful. What's up?
Number 14.
এই এটা রিলিজ করে দিচ্ছি নেই কেউ এখান থেকে নামিয়ে দিই এটা লেখো তো in view of our respective determinations comma it will be very difficult for us to take up this matter for hearing. Paragraph. This matter stands released from our list. Let the matter be placed before the Honorable the Chief Justice for appropriate direction.
I pay for the petition. This is a contempt application.
Mr. Ali, pass it over. Your friend is not there. Give them a chance. If they don't come in the second call, we'll take it up. Pass over Korun. Dakun.
16.
16, my lord, I appear for the petitioner.
16.
16.
Ghulam Rashid.
আমরা recent এসেছি।
Affidavits have been exchanged.
Well, I have filed on the last occasion the affidavit stating that the order which has been directed upon us, my lord, for consideration of the unauthorized construction issue, that was, my lord, decided, and my lord, the order has been passed already. That was there on the last two occasions.
Then what remains of the contempt? Let us see. The
They
infile.
have to demolish, my lord.
Demolition is not the issue right now because your lordship direction.
Let's see what the order is first. If they have to demolish for that.
Second occasion. The demolition part, we have passed an order. Then he wants to execute that order, which has been passed pursuant to lordship's direction, because lordship wanted a disposal of the entire issue within a certain time.
Let us see. Let us see.
একটা বিষয় very good. Another is very good. For execution.
Okay. This is second, lordship. The second page of the order.
Order dated?
Order dated 3rd December 2021. This is the order under which contempt has been committed. If this is a change brief, I do not have the entire brief.
It was the representation. And the complaint was made of the unauthorized construction in certain premises that was taken into consideration. Orders has been passed by the special officer building.
It is our case that the stop work has not been implemented. The full-fledged building now.
Yes, there were two parts to this order.
Lordship.
One was dispose of the representations made by the writ petitioner. You are the writ petitioner.
Lordship.
And the second was, in case stop work notice has been issued by the corporation, corporation will ensure that no further construction is raised, and the police will render assistance to the corporation. Now they say they have passed an order disposing of the representation. So what remains after that?
The
They will-
implementation is.
He wants the implementation of the demolition order, which has
No,
been
not the
passed.
demolition order. The stop work notice has not been implemented. So
Stop
the
work notice,
full-fledged
but
building that has
already
come up now.
Now that they have issued a demolition order, that they will have to implement
There is an
their own
independent
order.
course of action, Malad.
Yes,
that I have to
separate
pursue separately.
So let us dispose of this matter, Mr. Ali.
Lordship.
Issue. One second. This contempt application has been filed alleging willful violation of a judgment and order dated December 3, 2021.
Yes,
2021.
2021, whereby this bench had we had disposed of Mat 1281 of 2021 and the connected application. Stop. The operative portion of the said order reads as follows. Pink একটা ইয়ে দিয়ে দিলাম tag running page 28 কিসের 28 আমি জানি না 27 সরি এটা কি দেখছি দাঁড়া বলে দিচ্ছি সি প্যানটা বোধহয় হ্যাঁ সি প্যান কন্টেম্প্ট অ্যাপ্লিকেশনটা পিঙ্ক ট্যাগ হ্যাঁ paragraph. Affidavit in opposition has been filed on behalf of the alleged contempt, on behalf of the municipal commissioner.
There are 3 affidavits I see.
Who are the alleged contemnors? Who are the respondents?
Contempt,
All corporation.
Number of the officers are there. Some of the officers are not in the office right now. But however, we filed 3
Well, affidavits in opposition have been filed by the concerned officers of Kolkata Municipal Corporation who have been impleaded as respondents. Stop. It appears that when was the order passed, Mr. Ghosh?
well, on diverse days, because not in single day, because the 3-4 premises and numbers were there.
4 premises.
4 premises there, not in one day, my lord. That because the special officer building passed the orders.
It appears that the special officer bracketed buildings, bracket closed, has passed several orders disposing of the representations made by the writ petitioners in respect of the alleged unauthorized construction said to have been raised by the private respondents in the writ petition. Stop. Demolition orders have been issued upon it being found that, in fact, illegal constructions have been raised. Stop. Paragraph, we therefore see that the order of which violation is alleged, comma, has been complied with. Stop. What remains is implementation of the demolition order, which we are sure the corporation will do in accordance with law. If they don't do, file a writ, you know what to do. Paragraph, we see no reason to keep this contempt application pending. Stop. CPAN such and such is accordingly disposed of.
So only I'm submitting to your lordship. They got the demolition order in all cases passed. Exactly right now I cannot say because your lordship disposing of the demolition cases. Because sometimes the demolition and part detention, part demolition order has been passed in certain cases.
So you have disposed of the demolition cases.
Several
orders have been passed. কি বলেছি special officer building নাকি সব বললাম?
Instead of demolition orders, orders.
Instead of demolition orders, disposing of the demolition cases.
Disposing of the demolition representation না করে
Demolition না করে demolition order.
Several orders disposing of the demolition cases. Several orders disposing of the demolition cases. So,
I'm grateful. But please, Your Lordship, now for the petitioner. Pursuant to Your Lordship's earlier direction, my lord, I have served upon all the respondents' alleged contemptness, but they have already received it. I've got the affidavit of service as well.
Last time it was taken up on 16th April last year.
Yes. But this was with respect to, my lord, the unauthorized construction by the private respondent. And, my lord, I have got the order from the Honorable Single Bench, my lord, that it should be considered. And if it is found to be unauthorized, demolition. So, yes, my lord. But possibly, Lordship kindly sees Lordship's last order. They have already appeared before your Lordship. They appeared? Yes. Right. Kindly sees my Lord's last order. Kindly sees on the 16th of April once.
Alleged contempt. Who is the alleged contemptor?
The municipality, my lord, the chairman of the municipality. Another thing, my lord, I must bring to your lordship's notice that the chairman in this meantime is changed also.
Then you have to
I'll have to
new chairman. Do that first.
That affidavit of service will be taken on record. Once again, I'll serve and file.
Yes, sir, this is
I'll do that.
Over a year ago.
Yes, ma'am. Yes.
The incumbent in the post of chairman of municipality, Panihati.
Yes, yes.
Panihati.
My lord, it is, my lord.
In the post of
Yes, my lord.
Panihati
Panihati municipality.
municipality has changed. Stop. Learned advocate on record for the petitioners is granted liberty to implead the new incumbent as respondent number 2. Stop. Let necessary correction in the cause title of the content petition be made out by learned advocate on record for the petitioner. Paragraph. Let a copy of the content petition be served on the added respondent number 2 and affidavit of service be filed in court on the next date.
Lordship.
Paragraph. আমরা কবে নেক্সট বসছি বলো তো 8th August না একবার বসছি না?
But
8ই August একটা 8th August বসছি না আমরা?
I overheard that Lordship has posted other matters on 8th.
8th, এটাও 8th.
Great. But the earlier affidavit of service may not be taken on.
Paragraph. Affidavit of আরেকটা লিখে নাও. Affidavit of service filed in court today, evidencing service on the respondent number 1 is taken on record.
Great.
Respondent number 1 লিখো না, original respondent.
Item number 18.
This is an application for restoration, my lord, of your lordship's order dated, my lord, April 16, my lord, 2025. Within 24 hours, my lord, we filed this app. Paragraph 3-4.
Dismiss. Review application was dismissed.
No, review application I filed, my lord, of your lordship's
What
order
was
dated,
dismissed for default?
the review application.
That's what I'm saying.
I'm sorry, my lord.
Where's the order?
The order could not be
My lord, the
16th April.
16th April.
Where are you? You are for the
Mr. Banerjee is absent today.
restoration. This is an application for restoration of RVW 283 of 2023, which was dismissed for default on April 16, 2024. Paragraph. We have heard learned counsel for the appearing parties. Stop. We are satisfied with the explanation furnished for absence of learned advocate for the review applicant on the day the matter was dismissed for default. Paragraph. Accordingly, the order dated April 16, 2024, is recalled. Stop. RVW 283 of 2023 is restored to its original file and number along with the connected application being CAN 1 of 2024. Paragraph. CAN 2 of 2024 is disposed of. Paragraph. List the review application along with the connected application. We are knowing August 8.
April of this.
Item number 19.
In item number 19, Lordship, Mr. Mukherjee is appearing for respondent Uttarpara Kotrong municipality. The review application is infructuous, Lordship. The your
Yes.
Are you appearing for the review applicant?
no, Lordship.
No, my lord, I am for the review applicant. Mr.
I
Partho Sarathi Bhattacharya is on his legs, your lordship. He makes it or not today.
The application is infructuous, Lordship. Your petitioner filed fresh writ, Lordship.
Well,
History.
বলছে না কোনো?
Board review application of the not response. Respondent
Yes, what is the ground for review?
Or I'm being instructed, your lordship,
Instructed what?
to pray adjournment. Your
No, 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 argue the matter.
Sir, please appreciate this is a broken bench with great difficulty we assemble.
Tell us, what is the error apparent on the face of the record?
You are not briefed in the matter.
Oh, no, your lord.
Get yourself briefed. We will direct. Prepare yourself. We have heard you argue well. So on the next date, if Mr. Bhattacharya is not available, please argue the matter and finish it off. Promise?
Promise, your
Yes?
Yes, your lordship.
On that ground, we are going to adjourn this. What is your name?
Tirupati Mukherjee.
Tirupati.
Yes, your lordship.
Wonderful. So that's a
Kindly note my
solemn promise.
submission. Kindly note my submission.
Accommodation is prayed for on behalf of the review applicant. Paragraph. Learned advocate for the municipality says that the review application has become infructuous since the review applicant has filed a fresh writ application in connection with the same subject matter. Paragraph. As a last opportunity to the review applicant, we adjourn this matter and direct it to be listed on August 8, 2025. Yes.
Item number 20, my lord. I am for the review petitioner, my lord. Mr. Subir Chana has already completed argument on behalf of the petitioner.
Yes, completed, you have forwarded, now you argue.
Yes. My lord, that matter, my lord, Holdia Dock Complex. Petitioners are the land loser, both petitioners. Land were acquired by the state government in 1971. Admittedly, there was no scheme for rehabilitation. So, my lord, petitioner is residing temporarily.
Order under review is dated.
Sorry.
24th November
2021.
এটা কোনটা তাহলে 18টা
Appeal was, my lord, mandamus appeal was dismissed. Only sole plea, my lord, there is no scheme for rehabilitation of the uprooted person.
previous story also.
Then, my lord, against the petitioner, eviction proceedings was initiated, execution proceedings was initiated, and in course of, my lord, execution of the eviction order.
This was one order was passed by His Lordship Vishwajit Basu.
My lord, in division.
In division, that is dismissed.
My lord.
Thereafter, what remains?
Eviction proceedings was initiated under the public premises eviction of.
Yes, yes, we can recollect.
My
it.
lord.
That was passed against them, granting eviction. Against that, they preferred an appeal before the appellate authority.
Then appellate authority, then division dismissed.
Dismissed.
Then
a fresh writ petition was filed, which was dismissed. Against that, appeal was preferred. That was also dismissed.
That is a review order of review under challenge. Now they have filed a review application, and my lord.
What is the ground for
My lord,
review?
my lord, kindly have a look. I have filed one supplementary affidavit by annexing
They say there's a scheme of rehabilitation.
rehabilitation, my lord.
That is the only point.
Lord, point is
Petitioner has
rehabilitation scheme, if it is at all there, it is of the state government. Port Trust has got nothing to do. We have acquired, we have paid the money. And there was some excess land that we also handed over. So actually the fight is now for rehabilitation, if he has any case at all, between him and the state government. Port Trust has got, and for that reason he cannot occupy valuable commercial land of Port Trust.
They have provided us with a list of persons who had been accommodated by you only.
No.
That is the
No,
point
my lord.
taken.
We have not. There is no scheme at all.
My lord, one supplementary affidavit should be on record, my lord. I have annexed list of rehabilitated persons who are similarly situated.
Yes, where is that list?
My lord, I have all supplementary affidavit.
The garb of review, can new documents could be introduced, my lord? I am posing this question to myself. In the garb of review.
What is that list?
Well, I have annexed with supplementary affidavit.
Supplementary, you find out and show it to him that is it their list or not. How did you respond to this list? That is the only thing.
I have already supplied.
So far, Port Trust is concerned.
What have you said so?
I've seen it.
File your show us the part of the affidavit the way you have dealt with the list.
এগুলো যে হয়েছে কোথায় লিখেছিস যেগুলো পোর্ট ট্রাস্ট দিয়েছে
না স্টেট গভর্নমেন্ট
স্টেট গভর্নমেন্ট হ্যাজ প্রোভাইডেড
Mr. Bose, tell us, show us your affidavit. How did you deal with this list? What have you said regarding the list in your affidavit? You said that.
My lord, admittedly,
No question.
No. Point is, my lord, another point. This list pertains to those persons who has been rehabilitated by the state government.
We
not by
understand
the Port
that.
Trust.
That has to be stated on oath by you of an affidavit. Have you filed any affidavit to this or not?
No,
You are saying something at the bar, we cannot accept it.
They have filed affidavit in opposition.
Yes. So what have you said in your opposition regarding this? Kindly tell us. Place the affidavit.
Kindly give me a moment. Affidavit opposition.
ঠিক আছে, উনি পাঠ করুন।
My lord, I have stated it, page 5, Lordship will find. The opposition সাপ্লিমেন্টারি এফিডেভিটের কোনো অপোজিশন ফাইল করেছি মনে হচ্ছে না।
এই তো অ্যানেক্সটার আর করেছেন তো অ্যানেক্সটার আর হয়ে যেত
না দেখি তোরটা কি লিখেছিস।
ডিনাই ডিসপুট করে দাও।
এটা কত তারিখে 11 এপ্রিল 22 ভোট কাজে রাত কত Paragraph 10, na? The paragraph 10, my lord.
What have you said? Replace it.
The fact of validity and sufficiency under correctly. It is just a printed chart without any, my lord, signature or any authentication. So I said the factum and the validity and the sufficiency and the correctness of the purported chart being annexed R5 to the said petition as referred to in such and such supplementary they are disputed. The purported chart is bereft of any authentic seal and particulars and are vague. The purported chart does not contain any seal or signature of any authority and do not lend any credence to such case sought to be made by the petitioners in return.
Have you filed any reply to this?
Obviously, my lord.
What have you said regarding this? Who has issued the chart? What is the authenticity? How have you?
Well, state government.
What do we get this? The state government, this authority following this resolution. Suddenly a list.
Lord, I have also annexed a judgment of a single bench of this honorable court, Justice N.K. Mitro, wherein batch of writ petition was filed, and my lord, then his lordship was directed to for rehabilitation, for allotment of rehabilitation plot. I have also annexed that.
But
And
that
my
is
lord,
to the state government, not to the port trust.
state government, man, obviously.
State government.
State government
He's
acquiring body, state
whatever
government,
right
requiring
he
body,
is
whole their
left,
complex.
whatever right he has against the state government, not with the port trust. That's when port trust has initiated eviction proceedings, order passed against him, appeal preferred, dismissed, revision they came, it was dismissed. In that event, let them continue with their my lord, right against the state government. But the port trust land, they
have they been evicted?
No, my lord, we could not because of pendency. Your lordship verbally, my lord, directed that kindly stay your hands.
My lord, pension has fully been stopped.
Yes.
Petitioner's pension has fully been stopped, withheld, permanently.
That is not within the scope of this.
This is the list we are relying
Yes,
upon.
my lord, my lord.
What he is saying that this is it really bears no signature, no authority. How we can rely upon this?
State government supply document.
Moreover, admittedly, when the claim is against the state government, well, port trust cannot be settled with this, allowing him to burden of allowing him to stay in their land. Is it commercially viable land, my lord, without making any payment, any rent, anything?
This is a review application.
My lord.
Lordship.
What is the original order?
Original order. No.
Review petition at what?
Memorandum of review, lordship will find. Memorandum review,
Order dated
lordship will find.
16th August 2021. No, that's it.
Okay.
No. Because it's a matter.
The memorandum of review, the order dated 24th of November 2021 is annexed, my lord.
Where is the order of the learned single judge?
এটা কোথায় গেল? এই যে order date. Mandamus appeal তো 16th August.
It's my lord, Lordship will
16th
find
August
that-
2021.
Lordship will find that in the application.
Memorandum of appeal.
Right.
9th August, 8th August for orders.
8th August for all.
For orders. এই ফাইলটা পাঠিয়ে দেবেন।
Order under review will, my lord, is
You have
the-
not been able to produce any scheme of the
No,
port
madam.
trust.
My
Scheme is not there. You have come up with only list.
list.
What is the credibility of this list?
We have
You prepared on these points?
we have
Either show us any scheme
Hello, madam.
or you show us the yes, this is the list prepared under this scheme or that scheme
Madam.
by this authority.
we have heard learned counsel. We have heard learned counsel for the parties at some length. Paragraph, list this matter under the heading for orders at the top of the list on August 8.
Ask Mr. Shanal if he wants to argue that it is. Yeah.
I'll give you a black mark.
Don't ask.